Welcome again, everyone. My name is Jackie Kappas. I'm with Legal Decoder. Today we have Joe Tiano leading a conversation with Grant McGuire, as well as Professor Nancy Rapoport and Jessica Bilotta. We will be discussing several topics, and we always encourage people to ask questions and to comment as we go, because it will help us to understand what you're interested in hearing. I'm going to hand it over to Joe right now. And we will be doing a quick poll in the beginning to, like I said, get an idea of what your priorities are today. So I'm going to hand this over to you, Joe, and let's get started.
Well, thanks very much, Jackie. I appreciate the kind introduction. Thank you to all of the presenters in advance for agreeing to share their wisdom with us, and most importantly, thank you to all of the attendees. As Jackie mentioned, we highly encourage you to ask questions through the Zoom chat during the presentation. We'll do our best to address all of the questions that get asked. We've reserved about 5 or 10 minutes at the end for those questions. And then lastly, all of the attendees will receive an email with all of the course materials, which are going to include an outline, the presentation materials, and several scholarly articles that were authored by the presenters. So why don't we get started with Rule 1.5, data analytics and legal fees. So the place to start, of course, anytime you're looking at Rule 1.5 is with the rule itself. And ABA Rule 1.5 has one principle that is overarching throughout the rule, and that is that any fee or expense charged by a lawyer must be reasonable. Now, some states used unconscionable instead of unreasonable to indicate when fees have crossed over the line, but notwithstanding the difference in the terminology, the effect is largely the same. Now, about 90% of the time, Rule 1.5 will arise in two scenarios for most legal professionals. The first scenario will be in the context of putting together fee arrangements or engagement letters. The second context would be in the realm of fee disputes. There are some other things that Professor Rapoport will talk about. But when it comes to the first scenario regarding engagement, Rule 1.5 requires a lawyer to communicate to the client two things. The first is the scope of the representation, what matters are going to be handled. Very often, it'll address what matters are out of scope. And equally as importantly, it will address the rate and the basis for the fees and the expenses. And fee changes also have to be communicated to clients. So the question then becomes, how do you determine if a fee is reasonable and compliant with ethical rule 1.5? And there's an 8-factor test, which we've distilled down, which hopefully you're able to see on your screen. So the 8 factors are non-exclusive. There's no equal weighting of the factors. Other factors can be considered, but these are largely the factors that will be considered by a court, a bar association, or any sort of adjudicative body as they're determining whether the fee is reasonable or not. Now, it's important to note that high fees in and of themselves are not per se unreasonable, right? Just because a fee has a $1,600 per hour rate attached to it does not mean that the fee is unreasonable. And reasonableness is evaluated within the totality of the circumstances and throughout the entire relationship. So that's kind of how the approach is. Let's talk a little bit about the 8-factor test. So,
Joe, do you want to actually put up the slides?
yes, I thought that they actually were up. One moment, please.
Yeah.
While Joe is doing this, thank you to everyone that's voting so far in our poll. We will be ending the poll in just a couple of seconds. So please go ahead and just go and fill that out for us, and then we will publish the results.
Yeah, I'm really looking forward to seeing what people say there.
everybody's patience in the world of Slack, in the world of Zoom, in the world of all of the different technologies that we're having to work with now. People seem to become extraordinarily patient with the share screen.
So while you're sharing, Joe, everyone, I just shared the poll results as well. So we find this pretty interesting. Our panelists, I'd love you to take a look at that because I think that there's some clear patterns here. I'm going to go ahead and let you take it away, Joe, but thanks everyone for filling out the poll.
Sure. So in terms of the 8-factor test, again, they're non-exclusive and they're looked at in the totality of the circumstances. But let's get to the 8 individual factors. So the first thing that will be analyzed will be sort of the contextual input that needs to be put in by a lawyer. So what that is going to involve is the time, the labor that a lawyer will have to spend on a particular matter. There'll be an analysis of the novelty and the difficulty of the questions of law that are involved. The skill required to perform the particular legal services properly will be part of that factor. The next is the opportunity cost. And the crux of the question that gets asked here is, will employment on a particular matter preclude a particular lawyer from taking on other matters? Next thing that is evaluated is going to be the value. So largely a court, an adjudicative body will look at the amount involved in the result that is either sought or obtained if it's looked at in retrospect. The next thing would be client expectations. So there's a variety of different expectations that clients have. So the first will be the time expectations, client scheduling demands, and time limitations. So just by way of example, if emergency via a TRO is being sought or a complaint needs to be filed within 2 weeks of a statute of limitations, those are 2 scheduling issues that really need to be evaluated as they put some burdens upon the lawyer. The next factor that will be looked at will be the attorney-client relationship overall. So there'll be an evaluation of the nature of the relationship, how long it's gone on, and so forth. Another important factor is going to be the chops of a lawyer, what their professional credentials are. An adjudicative body will look at the experience, the reputation, the ability of the lawyers who are performing the services. And so this is the type of thing that will allow for elite partners at the Wachtell-Liptons and the Cravaths of the world to be able to charge $1,500 an hour. The last thing that is considered within the 8 factors is the fee structure. So the reasonableness mandate is imposed whether or not a fee is fixed or whether it's contingent. It applies to all types of fees, hourly, AFAs, et cetera. And it also importantly applies to all types of payment. So whether someone's getting paid in cash, whether someone's getting paid in stock, whether someone is getting paid in kind, it really doesn't matter. Reasonableness is still a keystone factor in what has to be evaluated. So those are the factors that are being considered, and from a practice pointer perspective, I think what's paramount is communication. Communication tends to make things more understandable, more reasonable. And from a practical perspective, there's 2 things that we'd like to share. The first is that there's a real refocus away from rates. Okay, budgets are now becoming the big thing. The rates tend to be very tabloid-esque, National Enquirer type headline grabbing things, but budgets are now becoming the big thing. The other thing is that there's a major emphasis now on outside counsel guidelines and adherence to outside counsel guidelines and making certain that they are getting enforced, often through sort of indiscriminate e-billing systems, but enforcement of the guidelines is important. So I guess as we're talking about guidelines, it's a really nice transition to Professor Rapoport. So from an expert's perspective, speaking of guidelines, you were intimately involved with the 2013 bankruptcy guidelines. Could you talk a little bit about the guidelines and your involvement and how you apply them as a fee examiner?
Sure, absolutely. The guidelines that Joe is talking about were promulgated by the United States Trustee Program in 2013 to deal with large Chapter 11 cases, those with at least $50 million in assets and $50 million in liability. And I had the pleasure actually of testifying when they were doing hearings to determine whether or not the draft of the guidelines made sense. I think I got invited because I spent a lot of time talking about attorney behavior in Chapter 11, which is my background. I'm a bankruptcy lawyer by training, and I do a lot of writing on lawyer behavior and reasonableness of fees. So when we all got to testify, we were all taking different looks at parts of the guidelines and how it might help not necessarily judges to determine reasonableness because they're guidelines. Unless a court enacts them, they're not rules. But it tells people how the United States Trustee Program, which is an arm of the Department of Justice, would view fee applications in bankruptcy. And for those of you who are not as obsessed about fee applications in bankruptcy as maybe Joe and I are, in order to get paid in a big Chapter 11, you first have to be approved for employment by the bankruptcy court, and then you have to submit fee applications, which are, in the bigger cases, I'm 5'2.5". If you stack them month by month, they're bigger than I am. And so what the United States Trustee Program was trying to do is to figure out, how do you get your arms around reasonableness? And as Joe is talking, context is really important. It's not just reasonableness in the abstract, like you can pull a number out of the hat and say this number is reasonable. It's reasonable in light of the work performed and the decisions that a lawyer makes. And recently, Joe and I have been studying attorney behavior as reflected in timesheets. And so you can tell a lot about how attorneys view reasonableness by the way that they describe what they're doing and the choices they make. Now, I get hired by bankruptcy courts to help the court review reasonableness as a fee examiner. And there are things that crop out that you think to yourself, what were these professionals thinking? And some of my examples include having a lawyer bill a shirt to the bankruptcy estate because he had to stay overnight and he had to buy a new shirt for court, or fancy meals with alcohol. And what those things are trying to indicate more than anything else is lawyers who have lost sight of how to establish reasonableness, not just in light of Rule 1.5 or their state's version of 1.5, but also in terms of the bankruptcy code's rules on reasonableness, which tend to dovetail how Rule 1.5 looks at reasonableness. So when you're looking at the communication between an attorney and the client outside bankruptcy, I have this image of an attorney pushing the bill across the table, and Joe is talking about outside counsel guidelines, the outside counsel talking to the general counsel, trying to justify the bill, and the general counsel pushing the bill back saying, nope, let's try again. Well, the reason inside counsel can do that is that it's coming out of the inside counsel's budget. In bankruptcy, for example, it's not coming out of an individual client's budget. It's coming out of the estate, either by unsecured creditors paying or out of the cash collateral of a secured creditor. So the check and balance, the blush factor test, more than anything else, is attenuated. There's a disconnect between the lawyers and other professionals who are doing the work and the people who are supposed to be reviewing the bill. So when I'm looking at compliance with both Rule 1.5 and the bankruptcy code, it helps a lot to get more context. Again, communication is key. Bankruptcy cases, at least big ones, are fast and furious. And so lawyers are making decisions on things like who should be doing what, how many people should be doing something, how many people touch a document before it gets filed. They're making those decisions in real time, but they're not necessarily justifying them in the bills in a way that the ultimate arbiter, in this case, a bankruptcy court, would be able to determine whether reasonableness makes sense. So my advice when people are trying to justify bills, either to a client who's actually paying the bill out of his or her budget, or when there's fee shifting, is over explain the decisions and tie those decisions to why at the time you did the work, those decisions were reasonable, rather than just saying, well, here's what we did, good luck with that, which is not as effective a process and will always trigger more questions and slower pays more
Yeah,
than anything else.
I always find, Nancy, just in kind of watching you from in the work that you do sort of from afar. I always like your philosophy about being a fee examiner, where you don't really act as an armchair quarterback.
Right.
You know, I don't, there's not a whole lot of second guessing the strategic decisions that are made by outside counsel. And could you talk a little bit about sort of the ask and explain philosophy that you use when you're evaluating the fees?
Absolutely, because there are different philosophies that different fee examiners have. My theory is most of the time people can explain the context for why they did work uh, with a conversation. That conversation better put in the bill and the fee application, but I always start with, tell me why you did this. And to back up a little bit, the reason Joe and I work so closely together is that I've been using Legal Decoder's data analysis to help me slice and dice the fee applications, which the best analogy I can get for a fee application is it looks a lot like a hospital bill. You get things that happen on a particular day, but no link between those things and how many people do the work or who does the work. So what Legal Decoder does for me is slices and dices the fee apps in a variety of different ways based on questions that I ask Legal Decoder to do. And then I take the analysis and I look through it. And then I go to the professional. I say, these things seem unusual to me. Help me understand why you made these choices. And then the professionals and I will go back and forth to see if we can reach some understanding about why those choices were reasonable in light of both the ethics rules and the bankruptcy code. Most of the time, explanations help. Occasionally, negotiations happen when I can't agree to tell a court that something was reasonable. So the ability to show data to a professional brings things into much closer focus than if I were just to go with a highlighter through thousands and thousands of pages saying, this looks weird, tell me more. It's not my job to do the case. It's my job to help a court decide what's reasonable. And that is my only job when I'm a fee examiner. So asking and then getting an answer with the understanding, excuse me, that most of the time when they're answering, they don't get to bill for that. Asking helps it, helps me understand what's going on.
Yeah, and at the end of the day, it's really about value and the tremendous value that lawyers can impart for a client, and value certainly comes with a price tag.
Yeah.
So Grant, when you're delivering outstanding value to your clients, how do you balance sort of the notion of thoroughness, you know, sort of the no stone left unturned notion with the Rule 1.5 obligation of reasonableness?
It is by the way, thank you for having me here today. But to get back to your question, it's a push and pull that goes back to what Nancy was saying before about communication with the client, having a thorough understanding of what expectations are. If one, as a practicing attorney, uh, goes at every file with the either scorched earth or leave no stone unturned approach, that is going to alienate any number of clients who have an expectation as to what their definition of reasonableness is. So to have an open dialogue from the onset with the client as to what's going to be happening. And we were also talking about budgeting before. Budgeting is an excellent tool both for the client and for the attorney, that you identify the work that you're going to see, that is going to be invoiced and submitted. So there are no, I shouldn't say no surprises, but as few surprises as possible, with the understanding that a document is not a document etched in stone. Rather, it is an estimate as to what should be expected. Because in my experience anyway, litigation is far from always predictable.
Yeah, absolutely, Grant. Absolutely, Grant. It's been a while since I practiced law, but one of the challenges that I remember, in being a billing partner, was having to reconcile Rule 1.5 and its applicability to every member of my team. I mean, very often, an invoice would come back and I'd look at it. I'm like, oh my gosh, how can we deliver tremendous value to our client? But there's this one outlier who just seems to have run amok. You do a lot of training with with your team, with your associates. Could you talk a little bit about how the types of things that you do to train, particularly the junior professionals, on how to basically bill so that they fulfill their Rule 1.5 obligation, and so that you fulfill your Rule 1.5 obligation?
Sure. One word that I used before was communication, and that was with the client. Communication also has to exist within the firm, that an associate, a paralegal, even a junior partner for that matter, has to have an understanding of what their role is. They have to have an understanding of what the budget is. So, in terms of training, these are ongoing conversations that take place with the entire team in terms of what is okay, what is expected, and I've got to keep an eye on the bills themselves to make sure that, as you just said, someone does not run amok, albeit with good intentions. They may have, worked with another partner or on another matter that was a situation where it was a no stone left unturned approach, as opposed to, I can imagine another type case where, let's say, you're a third party defendant and you have a much smaller role than the targeted defendant. So you've got to be careful with that. And you can avoid that by having an open line of communication with your entire team so as to avoid surprises in bills.
Yeah, absolutely. Nancy, as you kind of sit in the role of a fee expert, I think we've had this discussion before that, 9 times out of 10 or 99 times out of 100, I think lawyers want to do the right thing. They want to send the right bills to their clients.
Yeah.
There are the outliers. So, do you have any thoughts sort of around that as a fee examiner when you see the outliers, right? They are sort of the exception to the rule on how lawyers behave. Do you have any thoughts sort of around that?
Yeah, I think there are a couple of pressures that lead to outliers. And Grant, thank goodness you train people and keep an eye on a budget, because the more you do that, the more the clients are likely to want to pay the bills for the value that you provide. But I think law schools are a little bit to blame here, because we teach people to find every issue and go down every rabbit hole. And we forget to tell them that clients don't necessarily need you to chase every issue and go down every rabbit hole. So on the one hand, you have these fiduciary duties that say you've got to be diligent, you've got to do the right thing, you've got to focus on what the client's needs are, and you have to communicate. And there's this fear of missing out that lawyers, as the fiduciaries for their clients, say, oh my God, what if I miss an issue? I'm going to get sued for that. It's going to be malpractice. So there's a tendency on one hand to want to, and I'm going to use this word advisedly, overwork a case to make sure that they've done everything. And your duty is to do the right thing. Your duty is not to bill for every single thing that you do. And so there's billing judgment that matters. So one force for outliers can be the fear of missing something that will come back and bite the lawyer in the rear later for having missed it. The other is the pressure of law firm economics. Law firms have to make money to survive, and there are a lot of hot issues right now post-COVID. Certainly bankruptcy law is popular, insurance law is popular, there's a lot of litigation. But there are other areas that are not very busy right now. And there are lawyers worrying about whether they'll make their hours, how they justify their worth to their own firms. And occasionally that creates pressures to want to do more for a client than perhaps the budget suggests that the lawyer should do. So I think it's important for lawyers to realize that these two pressures, fiduciary duties and law firm economics, are there, and to have that in the back of their mind to say, let's do the right thing. And from billing partners' perspective, to go over the bills and say, okay, this was not the right thing. Let's think about how to reduce a bill accordingly.
Yeah,
My best example, by the way, Joe, is someone who had to do something immediately and there were only partners around that weekend. And so the partners had to do everything, which is when you got partners and that's all you got, that's all you got. But you don't always bill that at the partner's normal rate if the partners are the skill mismatch for that task.
yeah, and I'll tell you, that's very apt. I was just having a conversation not more than a week ago with one of our law firm clients. And one of the partner there said, we make more money when we're inefficient.
Yeah.
And I think he was sort of musing on that, but ultimately, while he recognized sort of the inherent tension in the economic model at a law firm and sort of the hourly rates almost as creating an incentive to be inefficient. The partner took a step back and said, look, I've got a rule 1.5 obligation to be reasonable, but more importantly, the partner realized that there were client expectations and an imperative to be reasonable from a business perspective. And that's the key. That's why I think, I say 99 out of 100 lawyers, behave the right way. And I truly believe that it's because there's a business imperative to be reasonable. And much of what the lawyers kind of take a look at, I think, is Rule 1.5 compliance through sort of self-investigation and through self-monitoring. And I don't know, maybe this is a good transition when we're talking about sort of self-monitoring tools. Jessica, I mean, you're sort of elbows deep on a day-to-day basis, looking at sort of data-driven models of reasonableness. Can you talk a little bit about what you see sort of the software surface in terms of reasonableness and so forth?
Sure. Thanks, Joe. So yeah, I mean, when we're talking about, all of this analysis being done, obviously it would be much easier to have some sort of, as Nancy mentioned, using Legal Decoder or some type of legal spend analytics tool that can help firms, better analyze the data that they have. So basically what these tools do is programmatically analyze massive volumes of legal spend data and help establish reasonableness in two ways. So they help us benchmark pricing and budgeting against industry-wide standards, and they allow us to analyze billing according to objective metrics. So for example, our compliance decoder uses a proprietary rule set, and it includes 46 flags, which we use to highlight a firm's compliance with Rule 1.5 in general, but with regard to reasonableness specifically. So what we use to measure reasonableness are these three categories, and these are the categories that our flags fall under. The first would be staffing efficiency. So is the right person performing the right task in the right amount of time and for the right price? An example of these types of flags that would come up. So if we got a time entry or a narrative that was not following these staffing efficiency rules, they would trigger a flag. And just an example of some of the flags that fall under efficiency would be administrative work. So if we see, and I do see this a lot in my analysis with, the data that we get, partners or even associates billing for filing motions or doing docketing work, things like that, that the firm may consider administrative, but they're charging the client to do. at a higher rate, or a skill set mismatch, which could include either being overqualified for a specific task. So that goes back to that, the right person with the right skill set to be doing a particular job. So if we have a partner doing like a routine motion to compel, for example, or things that we know a lower level associate or perhaps even a paralegal could be doing, that would be considered a skill set mismatch, overqualified. And the opposite of that being, of course, an underqualified person taking on emotion, or maybe an appeal brief, something that is way out of their league if they're only a first or second year, and thus taking a lot more time and billing a lot more time for that particular task. So that has to do with the staffing efficiency flag. The next is the workflow efficiency. And that flag helps us to identify waste and redundancy and repetition in our workflow process. So example flags for that would be excessive status updates or excessive research. So we flag for that to see any issues with workflow efficiency. And then finally, billing hygiene. And this is a term that we've coined at Legal Decoder, which really deals with how the time entries and narratives should look. So the issues with narratives is really not so much that the attorneys aren't doing the work or that they're billing improperly necessarily, but it might just be that their narratives just need a little bit of work. So for billing hygiene, we want our time entries to be clear, concise, and accurately reflect the work done. Examples would be block billing, which is self-explanatory, and repeated narratives, which brings me to our example here. So if we look at this slide, this is just an example of something. This is something that Joe had, saw in his analysis over the years, and I asked him to share this with me because I thought this was a really good example. I've seen many of my own, but this particular partner for vague entry, so this would fall under the efficiency aspect here. So this person put in 198 entries. You can see the total amount of hours billed, and the narrative description over a period of 8 consecutive months was correspond with multiple parties regarding restructuring strategy and tactics. So could you be more vague? I mean, like, it's just a lot of entries, and it's just duplicative, and that really doesn't tell the client how much work, what work you're actually doing. So this may very well be justifiable. It may be something that has to be done like it was entered. It just is, you're not giving us enough information. And if you just make the narrative a little bit more clear, you will have no issues with billing or complying with the reasonableness under 1.5. And then the next slide real quick.
Jessica, before you get to the next slide, I wanted to emphasize, look at the difference between what got billed and what got paid. This is what happens when people don't describe things correctly.
Right. And when they see that there's a lot of entries for the same exact thing over a long period of time and the exact amount of hours, it's a little bit, I think they don't think people actually look at the bills. And so the overly verbose flag is the converse of that. So this is the opposite, where somebody just writes a missive. They've got like a whole novel about what they did, but when you really boil it down, so if we look at these entries, and I apologize, I know this is an eye chart. Could you, thanks. Okay. But you can see just by the length that these entries are just, rambling. But when you go through all these words and you see what actually was done, like let's take for example, this line right here, you really had a call with B. Smith, and who attempted to call this other individual. So, I mean, in all of that, this is really all that happened. And what you actually paid for is an internal call with an unclear topic and one attempted call to a colleague with an unclear topic. So some people like to bury a lot of, or their entries or their work into a lot of words. It makes it look like they were doing more. And again, not to accuse or say that people are doing anything that's not above board, but it's not always, more isn't always better. So it's just a matter of capturing accurately, but not going going overboard.
Yeah, let me
So
jump in. Let me jump in here for a second. Grant, software, right? Software uses algorithms. Software is objective. Software doesn't have judgment. Okay, software's got no judgment whatsoever. So, what are some of the things that you've seen software surface as, we'll use my air quotes, unreasonable, but were actually quite reasonable?
Some of my favorite clients or former clients, this goes back to the 1990s when the software, what I would call the software cops, started looking at legal bills, at least in my experience. Uh, the software would look at anything that was not court related, and flag it as non-attorney related. Anything discovery related, certain software programs would say paralegal only. And then it became a question of, do you want to fight it and explain why? As Nancy said before, essentially show and tell, or do you just want to let it go through and not waste your time on a non-billable event? So some examples of what is legitimately necessary, if you can imagine a discovery issue where you've got to go through tens and thousands of pages of sensitive material. Okay, so a paralegal can do some of that, but there's a privilege log and there are questionable entries as to what is actually going to be designated as privileged and non-privileged. I would argue to the software that at least part of that review is 100% justified to have not just an attorney on it, but an experienced attorney. You cannot just look at something and say, since it sounds like it's discovery, it's not justifiable to have an attorney, let alone a partner, involved in that discovery. That's one example.
yeah, Grant, on that, when I was practicing, I remember we had some clients that specifically requested that a partner work on particular things or a matter, and that there was very little involvement for lower level associates or even paralegals. So sometimes that's even at the behest of a client who says, we only want, Mr. Partner working on this, and we don't want any associate time, or it could be the opposite. So yeah.
Yeah, let me jump in here now, just for purposes of those who are looking for CLE credit. There's a code that we need all of the attendees to write down if you want CLE credit, and it will be code L as in Larry, code D as in dog, 1215. Again, that's code L as in Larry, D as in dog, 1215. Unfortunately, we're not going to be able to circulate this around according to CLE rules. So let me repeat it one more time. The code is L Larry D dog 1215. So let me just kind of punctuate a little bit about what Grant, you and Jessica were talking about in terms of flagging things. And oftentimes it seems as though the flags have sort of a negative or a pejorative connotation to them. Well, I think actually the converse could actually be true, where if you many of the flags come with the explanations that you just articulated. I think also oftentimes the lack of flags actually are a differentiator, right? The flags can be used for monitoring. The flags can be used for coaching our younger colleagues. The flags can be used for self-assessment opportunities, right? Before they actually even hit the client's desk, so to speak. But the flags could also be used as a business development opportunity. And this is important for lawyers and law firms to think about. If you're able to use data, go out to your clients and say, hey, we self-assess, we self-govern, we deliver fantastic results for our client, but we also know that we're more efficient than all of our competitors. that is an outstanding business development pitch. Clients are clamoring for law firms to come to them with very unique data-driven insights, different types of fee arrangements, and different measurements where the clients can basically say, we have this law firm as our trusted partner. The law firm came to us. The law firm says, we're actually, based on the data, more efficient than many of the other firms that we're considering. All things being equal results, equal competence, equal complexity of the matters. If there's a firm that comes with the data and says that we're actually better because we're efficient, we self-monitor, guess who's going to get the work? It's going to be the law firm that actually has that data. So let me move on a little bit. You guys talked about budgeting and in communication, and so let me talk a little bit about sort of using data to budget with greater specificity, with greater particularity. So I went through some of the historic data that we had at Legal Decoder, and I chose something like $500 million worth of data, which is a fairly representative data set. And the whole principle, I think, here is you need to plan the work, and then you need to work the plan. Right? If you do that, you really mitigate, reduce your Rule 1.5 exposure, but not only that, you really enhance your Rule 1.5 compliance. So the data that I pulled down again was about $500 million worth of litigation data, and when it gets properly categorized, you're able to establish some of the metrics. So what some of the codes that are out there, they're called UTBMS codes. We find that they've got some severe limitations. So the first limitation, I think, with the UTBMS codes, which is really the most practical limitation with the UTBMS codes, is the UTBMS codes have to be input by attorneys, right? So when you think about it, you've got a lawyer who has to keep their time in 1/10 of an hour segments, which is a complete drag. And now you foist upon them the additional responsibility to properly categorize their data according to certain codes. Just double the drag factor, right? So that's the first limitation. So it's done half the time, and the other half of the time it's done wrong. So the goal that we have at Legal Decoder, at least, is to actually take attorneys out of that process, allow the software to actually tag the data. And that's what we've done here. So the software basically reads what a legal professional is doing, and then it tags the data. So here, what I did is I basically looked at the codes that relate to discovery, right? So of the discovery codes, this is a static image, but we have a dynamic dashboard that could show the drilling, but I just wanted to get it so that people could kind of understand it better. So if you take discovery of the $500 million of discovery, and you drill down to sort of a first level of discovery, it wound up being about $75 million worth of data. If you then drill down to the second level, which is within the ambit of discovery, if you take a look just at the work that's related to depositions, it was about $11 million worth of data. Then if you drill down another level and you focus only on deposition, attendance, and review, it narrowed the universe down to $329,911, right? So now we've taken it from the macro down to sort of the granular through several phases, through several tasks, through several activity levels. And then if you focus on what I focused on here, which you could see deposition outlines with the search that we did, we now know, right, that for deposition outlines, a very discrete task, right, partners on average throughout the data set spent about 11.5 hours reviewing deposition outlines. Associates spent about 88 hours preparing, reviewing, revising deposition outlines. Paralegals about 8.7 hours, which when you think about it in terms of reasonableness, the allocation, the breakdowns and so forth, from a staffing mix perspective, with associates doing, the lion's share of the work and partners and paralegals doing not as much of the work, you now are starting to not just establish what from a budgetary perspective things should cost at a task or an activity at a phase level. You're actually able to drill down and say, yeah, this could potentially result in this matrix that you see, right? So if you're taking a look at sort of the matter complexity in a task, it shows sort of a matrix of what could be reasonable, unreasonable, and in this case, ultra reasonable. I mean, Nancy, you and I had sort of an offline discussion on this type of matrix. What are your reactions to this?
I think it helps in a couple of ways. One is it's an internal check for the professional. Am I using the right person to do the right thing at the right time so that I can justify my fees? But it also helps a professional figure out how to explain that to the person who's ultimately going to be paying for it. So for example, if they're really, lawyers have a bad habit of thinking everything is unique. Everything isn't unique. There are unique aspects of every case, but if you're going to spend more time or put higher level people on something, being able to explain why, even within a grid like this, it's still more efficient and more reasonable to use a higher biller to do an extra complex task than it would be to have a first or second year associate flail around for a while. Being able to put it in this kind of framework, again, with reasonableness as a range rather than an absolute, is a way of making sure you stay compliant and stay competitive when you're doing a beauty contest against other firms who are bidding for the same work. If you can say we can demonstrate that the way we do workflow keeps things in the reasonable area, it's helpful as a client is trying to shop who's the right firm to do something, to be able to justify to the client's bosses, I picked this firm because this firm has sensible workflow and sensible staff allocation. And I'm sure, Grant, when you are arguing to or doing a beauty contest, it helps to say how you train people, how you manage budgets, because it gives the client a lot more comfort that you're taking that client's needs seriously.
That's accurate because I'm not getting many clients just based on my own good looks. So yeah, a little bit of data would help.
Yeah.
Yeah, and the thing that I find most striking when you kind of put together this matrix, it really reaffirms the thesis that I've had for my entire career, is that lawyers actually deliver extraordinary value.
Mhm.
It reaffirms my thesis that most of what lawyers do falls into the ambit of needed or reasonable. 3 out of 4 quadrants,
Mhm.
when you look at this, really speak to Rule 1.5 compliance. And when I say that 99 out of 100 are actually complying with Rule 1.5, the quadrant actually really speaks to that, where it is the outliers where you've got high prices being charged for low complexity work. It just it very often doesn't happen. And so, that's it's sort of a from a former practicing attorney's perspective, it's incredibly reassuring, and it all proves out in the data. The other thing that you mentioned, Nancy, is really interesting when you said that there are, no two matters are created equal, and I completely agree with you on that. What we found interesting as we've gone through many of our data analysis, that's very true, right? No two matters are created equally. But what we're really talking about is the periphery.
Yeah.
Right. What you're really talking about are really the fringes, the edges, how you want to say it. And those are the aspects of the legal matters that are sort of the variable. For 80% of what lawyers do on a day-to-day basis, I'm not going to call it commoditized, because I don't believe in any world that what lawyers do is commoditized. But what I do believe it is I do believe it is recurring. I do believe it happens often. I do believe that there are natural evolutions, natural anatomies, natural ways that cases or matters or what have you progress along sort of a spectrum. and you can actually compartmentalize that piece, and you
Mhm.
can actually price that piece according to industry benchmarks. Yeah, sure, you're going to get the ruling from the judge out of left field, or you're going to have the, yeah, but my number two deputy was on maternity leave or paternity leave or on disability, so I had to staff it with a different person, right? But for much of what lawyers do on a day-to-day basis, okay, it's highly sophisticated work, but it's also, from a data perspective, it's compartmentalizable.
Yeah, it actually blows my mind when I hear about law firms bidding for work saying you should hire us because we are the most experienced in this particular field and we have no idea what something should cost. Those two things don't go together. So when Grant can look at a client and say, look, this is why I budgeted this. These are the assumptions that I make. It gives the client some comfort that Grant knows what the heck he's doing here, and it's not just throwing darts at a dartboard.
Yeah, I think that's right. So let's see, Jackie, did we have any questions from the audience that we want to address, or shall we talk a little bit about the polling question and the results?
Yes, so we haven't had anything that I think isn't being covered, but I would like to go back to that initial poll that we did. Instead of sharing the results, I'll just say that the two clear winners in terms of things that people are interested in, clients objecting to parts of your bill seems to be a main concern. As well as the market level rates that still keep you, which I apologize to everyone that got cut off, but I think that you read between the lines. So it seems like most of our audience are really interested in making sure that their bills are clean and also able to attract potential new clients. So I think that we're covering it. I would like to have everyone ask questions. I see that we have one that just popped up. My panelists, can you see that question?
Yep.
Great. I'm going to hand it over to you.
Okay, so the question is, what happens when you're dealing with a small firm or a solo? What should that attorney do about lower level work? So the question is the attorney expected to charge at a lower rate if doing administrative work if there's no lower level associate or paralegal to do it? And you're going to hate this answer, but I think the answer is yes. Even if an attorney at a particular rate charges, let's say $400 an hour to do something, if the work that professional is doing is purely overhead, that should be a no charge because it's not value to the lawyer, it's value to the client. And if it's something that a lower level associate would do, if that solo had a lower level associate, I think adjusting the rate helps a lot in terms of building client comfort that the lawyer is looking out for his or her fiduciary duties to the client. But I'm only one opinion. What about the rest of you guys on the panel?
Well, I think one thing that's really interesting, and again, the data kind of bears this out. Very often, people get focused on sort of the price, right? And the price is the component of two multiplicands, right? The first multiplicand being the time, the second multiplicand being the rate, right?
Mhm.
So if you focus on the time input that it takes for a particular task to be completed, let's pull an example out of the air. A motion to compel expert testimony, right? If you've got a fifth year associate at Sullivan and Cromwell preparing a motion to compel expert testimony, and it takes 5.7 hours, you could have a similar associate at a um, 3-person wage and hour boutique law firm in Walnut Creek, California. All things being equal competence, equal complexity, it should take 5.7 hours, right? The price, because of the rate differential, will be vastly different. But what we're finding and what the data is bearing out is when you look at things at a task level, okay, the time that it takes is very much similar. So in terms of answering this question, right, if you focus on the time input, then it should be very, very close. And when you talk about the ultimate cost, that winds up being the client decision, right? The client is making a value judgment. Do I want to pay a $700 or a $1,500 per hour rate, or do I want to pay a $300 per hour rate? So what happens is it actually shifts the decision back to the client if you know how much time a certain task should cost.
I don't want to interrupt, but we do have a second question and we're running out of time. Grant, I'm sorry if I cut you off here, but does the panel see the next question about opportunity cost? I think this is an interesting one.
Yeah, who's going to take this one?
Grant, why don't you take this one? Does opportunity costs play a factor when lawyers need to charge less for administrative work?
Well, I need to know what opportunity cost means in this context, not at the risk of being difficult.
So let me give you an example. If the lawyer has to do administrative work and then has to put off doing other more lawyery work, should that factor into the rate? So if I have to file something in court and that keeps me from finishing a brief, should that matter in terms of my billing rate?
Well, I would look at the totality of the circumstances, which takes us back to 1.5, which is not hard science. And at the risk of sounding like I'm, trying to weasel out of this answer, I would say it depends. It depends. I don't think you get an automatic pass that just because you're not doing other work that you could be doing, that you're entitled to bill at a higher rate. But let's take this to an example where something emergent comes up on a late Friday afternoon or even over a weekend, and your associate, your paralegal, they're not available and something has to get filed immediately. And your 15-year partner is the one who actually has to do it. I would say in that situation, yes, that is an acceptable entry on an invoice. But if this is a partner who does not necessarily have to do it and it could be delegated, then I think there would be a little more susceptibility to someone such as Nancy saying not so fast.
Well, that's great insight. We're at the top of the hour. Thank you very much, Jessica, Nancy, Grant, Jackie, for this insightful presentation. Thank you, attendees, for joining us. As you see, hopefully on the screen, everybody who has been in attendance will receive an email with all of the course materials and will receive information on how to get the CLE credits. So again, thank you.
And I know I'm risking being the teacher handing out homework just in front of the bell, but I am going to launch a poll right now. We are interested in hearing in other topics that you would want to hear about. So I'm launching it. If you have time to do it, great. If not, thank you for joining us.